Hello, welcome back. This is Roger Royce, the host of the 10,000 Startups podcast. I'm a partner with the law firm of Haynes Boone, resident in Palo Alto, doing emerging growth and venture capital. Today, we're going to talk about an issue that you as a startup might not be thinking about today, but you will be thinking about it, hopefully, when it comes time to exit. And that's the Hart-Scott-Rodino filings. And before you sign off, because that sounds too technical, you might want to stick around because you might be surprised when this applies and what you have to do to comply with it and what happens if you don't. Our speaker here today is Larry Shosid. He is a partner in the corporate and real estate practice groups at Haynes Boone's Dallas office. His practice focuses on mergers and acquisitions, securities offerings, corporate partnership, international lending, and of course, antitrust, including Hart-Scott-Rodino Antitrust Improvements Act. So Larry, thank you for being here today. And, this is a topic that, we've never covered before. I don't think I've even mentioned it, even in our M&A stuff. But, it does happen and it does come up, and it's something people, once people went through it, they're aware of it. But, how do you know when you're supposed to be when you're supposed to be aware of it? So let's kind of start off with, maybe you could tell us a little bit about just what is HSR, what is Hart-Scott-Rodino, and why do we care?
Yeah, thanks, Roger. Thanks for having me today. In its purest sense, I would say HSR is the anti-merger statute for the United States. It basically gives our Federal Trade Commission, the Justice Department, a chance to review proposed transactions to ensure that there's not an adverse anti-competitive impact upon a particular sector or market.
Okay. And so generally, who does this apply to? Because that sounds pretty broad, adverse.
It does. So if you distill it down to its basic terms, it's subject to certain size transactions involving certain size parties. So you basically have to, the transaction has to be a certain size. And right now, as we speak, the current minimum size for a Hart-Scott-Rodino filing, and when we talk about the size, we're talking about the purchase price or the consideration, has to be $119.5 million. And that could also, if you get anywhere close to that, you'd want to have it reviewed by an antitrust counsel, because it's not simply the amount of cash or consideration or like kinds of consideration that's being paid. It could also include, indebtedness assumed and other types of consideration. So you want to be careful that if you are subject to the act, that you comply with the act. So size of the transaction, and then you also have the size of the parties. So one of the parties has to have sales or assets of $23.9 million. And the other party of the transaction has to be basically 10 times that size. So $239 million of sales or assets.
Let me, so I understand. So you gave me a lot of numbers there. So one was 119.5. That's the size of the target, right?
Size of the transaction, right?
Oh, size of the transaction. So,
yes.
So if we're buying stock for $120 million, we've met that target.
Yeah, it's the fair market value of the stock, Roger. So if you're a public company, it would be easier to determine otherwise.
Yeah,
you can quite often what the do is simply the purchase price of the shares.
Purchase price. Yeah, that makes sense. And if you're buying assets, you're saying you might have to add in the liabilities assumed as part of the purchase price. So it's like enterprise value.
Correct. And we could get into the weeds a little bit. Even if you buy stock, we just had this issue come up, and I don't want to get too far off track here, but if you had a stock deal and like a small, it wouldn't be a small startup, but you have a startup and the founders have personal guarantees out there. And in connection with that transaction, that indebtedness is retired. That also could be considered part of the size of the transaction and contribute to the $119.5 million size requirement.
Okay. Then there was another requirement you mentioned, and is this an or an and test? Does it have to be both?
It can be or. You can have sales or assets that meet meet the size of the parties test.
Okay, so the 23.9, was that a sales test?
So that's sales or assets, and that's using your most recently completed balance sheet, or for assets, or your most recent probably annual statement for sales, annual income statement.
Oh, I get it. And then the acquirer in that case then has to be 10 times that size.
Right, or it could work. I guess you could have David acquire Goliath, right? And you could conceivably have a much larger transaction. But yeah, typically the acquiring party is the larger entity.
Okay, so you got to run the gauntlet on both those tests.
And I should mention that if one of our, somebody listening is fortunate enough to have a size of transaction that's $478 million or larger, that the size of the parties doesn't matter. You would have to file if your size of the transaction is 478 million or more, you have to file regardless of the size of the parties. Although in reality, if you had that large of a transaction, it'd be hard to imagine that your parties wouldn't be of significant size as well.
Right, gotcha. Okay, so now let's suppose we are lucky enough to have a transaction of that size. We're going to have a very successful exit. What does it mean? What do we have to do?
Well, what you do is you prepare what's called an HSR form, and you file that with the FTC and the Department of Justice. And the form itself is not really intuitive at all, and so it involves you're including a lot of market analysis, some market analysis in your filing. You have to determine who the ultimate parent entity is, and for a corporation that's in the transaction, the ultimate parent entity would be the person. You go up the chain of ownership, but the person that controls 50% or more of the voting stock, or the right to elect 50% or more of the board of directors, would be your ultimate parent entity. And if you're an LLC, which is, as you know, is what we see, quite frequently these days, it's basically 50% or more economic interest in the LLC. So you'd have to determine who the ultimate parent entity is. And they also look at, we also have to include, financial statements. We also include recent, some of the analysis of the transaction that was prepared for the company, the board, executive officers, to analyze the transaction to the extent it contains any competitive analysis. You would include that as well. And you file that, and as you probably would expect, there's a filing fee associated with that filing. And that filing fee right now starts at $30,000.
Yikes.
And that can go all the way up to $2,335,000 if your transaction's over $536,500,000. So it's definitely not an inexpensive, proposition to make this filing.
And that's just a fee to the government. That's just a cost, right? And so tell me, is that a difficult filing? It sounds like it's pretty involved.
I mean, we do them on a regular basis, but if you were, there's a learning curve like anything else, like any other skill in life. But yeah, I mean, if you're going to want to engage experienced legal counsel to help for you to prepare that form, someone does it on a regular basis, someone that knows what they're doing, because you don't want to, you want to get the form right. And then also there's a 30-day waiting period after you make the filing before you can make the transaction. And if you don't make the filing right, and the FTC comes back and says you missed something or you need to correct this, then that 30-day period starts again.
I got you. Yeah, so 30 days. So we file it, then we wait 30 days, and then we can close, or are we waiting for like an approval or some sort of
What's sort of interesting about this whole process, at least to me, is it's not an approval process. It's an absence of objection by the government. So you're really waiting. You really want your goal is for not to hear anything from the FTC or the Department of Justice during that waiting period.
I see. Okay, so it's gonna set us back by at least 30 days, is what it
Right.
sounds.
One other thing I can mention is, and I should mention, is you can file the HSR form off the letter of intent.
I was gonna ask,
Yeah,
when
or you can file it off the definitive agreement, and it all depends on the facts and circumstances and what the parties want to do. But usually you'll file off the definitive agreement for a number of reasons, but it's not uncommon to file off the letter of intent.
Mhm. And then if if it doesn't close, I guess it's you're out the filing fee, but other than that, it's no harm, no
Yeah,
foul.
there's no refunds. It's not like filing your taxes.
Okay, and yeah, it doesn't mean you have to close, I guess, if you file it.
Yeah, I mean, usually there's it all depends on the industry and the clients, but there are can be very robust provisions regarding the Hart-Scott filing under the in your definitive agreement, and typically you don't have those same robust provisions in your LOI. But you want to provide in your definitive agreement what happens if you get what's called a second request from the FTC, which means basically within that 30-day period they request additional information.
Oh, they can do that. So they could hold your deal up more than 30 days, it sounds like.
Correct. Hold it up or not allow it to happen, and basically file an injunction against transaction closing. Now that's unusual, but it does happen, and it's happened more frequently under the Biden administration than it has under Trump the 4 years before Biden. So it does happen, and I think everyone has their own opinions about how likely it is for a transaction to be reviewed, but there's certain things that the government cares more about than other things. At least people think that, and from a consumer standpoint, the government doesn't want an anti-competitive merger that's going to increase healthcare, that's going to cost somebody more money to buy their groceries. Those types of things really draw, the attention of the government. Energy prices, those things.
Yeah, I should have asked you about that, what we mean by anti-competitive, because a lot of times when we think of antitrust, people think, oh, that's just for like that's the Googles and Apples and Microsofts of the world. But at those numbers, that applies much more broadly than that, doesn't it?
It could. I mean, obviously, any transaction that falls under Hart-Scott is large enough where at least it's a possibility. But the government looks at market share, overlapping products, the industry you're in. They look at a bunch of different criteria. They have a lot of data that they use to analyze a transaction just to confirm that it's not going to have an adverse impact upon the public.
Yeah. Now, what happens if a company says that's a big hassle, it's a lot of money, I think we're just going to not do it and hide in the weeds here and hope nobody notices, and they get caught? Is there anything bad that would happen to them? Are there any non-compliance penalties or anything like that?
Yeah, it's interesting. That's an interesting question because these days the government, by the way, you can ask the 30-day waiting period. There's technically you have the right to ask for early termination, which means the FTC, DOJ looks at it, confirms before the 30-day period that there's no issues and you can proceed with the transaction. But under the Biden administration, those early terminations have almost become non-existent. Very low probability of that happening. And because of the current administration, there are some companies that have, I wouldn't say thumb their nose up at the government, but have closed without waiting for the government's absence of objection, so to speak. That has happened, but I don't think there's a lawyer in the land who would advise their client to do that because if the government wanted to, they could impose a penalty and the fine. What is it? I think it's like $56,000 a day for a violation.
Holy cow!
It's very significant. So, oh, I'm sorry, it's a little less than that. It's about 52, a little under 52,000.
Mhm.
One thing I do want to mention, and we should also be aware of this, is the FTC and the Department of Justice can get involved in a transaction, even if a filing under the Hart-Scott-Rodino is not necessary. If there's been like a pattern of, when we had a client that was acquiring roll-ups, and the government's been particularly interested in roll-ups, but a bunch of smaller acquisitions and gaining market share, and we had to do some really hard analysis to get some comfort that we didn't believe that this was going to be anti-competitive and something that the government would come in and scrutinize, even though no Hart-Scott-Rodino filing was required. And we've had I remember early in my career, I had a client that it was in the media business, newspaper business, back when people read newspapers, and there was a consolidation. It was below the threshold that the government came in and made our client divest of the acquisition after the closing had occurred. So just because you're not subject to Hart-Scott filing doesn't mean the government can't become involved with your transaction.
Yeah, and it sounds like you've been doing this a long time, and it sounds like the government's getting tougher on antitrust. Is that right? Am I hearing
They are
that?
right now. It's as you can imagine, like these days everything's political, and so I think the Biden administration's been more aggressive than the Trump administration was before that, and
Hmm.
even the Obama administration was before that. So, these different agencies can take on the personality of whoever's in office, whoever's in the Senate, and so Congress. Yeah, it's been more aggressive in the antitrust area than it has been, in recent history, for sure.
Okay. Now, a lot of times we see, especially where I am out in California, we see a federal statute, and then the next thing you know, there's a state statute that kind of does the same thing. With its here in California with its own little flavor, California flavor to it. Is this purely a federal filing, or do we have to worry about state laws as well?
I mean, the states can get involved in it. Most states have, I think, an antitrust statute, anti-competitive statutes. I think it's unusual for a state to get involved, but they certainly could. And they don't. I'm not aware of a state that has any antitrust filing. I don't think there is one, but yeah, there's not. That's not. It's really a federal filing, but the states couldn't get involved from if there's something antitrust. That's particularly their state, they certainly could get involved in that. And we know California likes to involve itself in a lot of matters.
Now, so it's interesting that this could happen for smaller companies again, because you keep thinking about what you read about in the papers. And it causes me to wonder, are there other antitrust issues that startups really need to think about as they move forward and expand and get acquired and do roll-ups, as you say, or combine? Or is this kind of really the main thing?
I think you always need to have be aware of those types of issues. Like I said, just because you're not subject to the act doesn't mean you couldn't have an antitrust issue. And one other thing to keep in mind, these days I was mentioning, some companies are actually, they call it, I can't remember what the term is, but basically you license your software, you license your technology to a larger company like Microsoft or Apple, Google, and they don't really acquire the business, but you have this license fees, and they basically, it's sort of an indirect acquisition, it's called. And so you'll see that out there in the marketplace these days. And one of the reasons that's done is so the FTC and the DOJ doesn't have an opportunity to scrutinize the transaction. But yeah, I think you always need to be aware of that. And I think also as you contract with other parties within your same space. So there's also a thing called gun jumping, right? You have you're subject to Hart-Scott, you file, or before the 30-day period is expired, or you receive early termination, you start basically collaborating with your target or vice versa to win business or divvy up customers or take over markets. And there was a case last week, actually 2 weeks ago, with a company that the FTC actually fined, I think it was $3 or $4 million because they had gun jumped and were, doing anti-competitive things they shouldn't be doing before they were before the acquisition occurred. So you need to be aware of that scenario as well.
Yeah, gotcha. Okay, well, is there anything else we need to know about Hart-Scott-Rodino that I didn't ask that I probably should have?
No, I think those are really the basics, Roger. And so you just want to, I would say a rule of thumb, I think people say, is you get any transaction that's, has total consideration of anywhere around anywhere above $90 million, you at least ought to engage counsel to review the terms and confirm and make sure that you're, whether or not you're required to make a filing. I think any counsel that's has any significant or even moderate experience in mergers and acquisitions and capital transactions is going to, look at that and perform that analysis in connection with the transaction. So I think it's helpful, like you mentioned earlier, just to know the basics, what it is. It's a way for the government to scrutinize acquisitions, mergers, and similar type transactions. And just be aware that if you're fortunate enough to have a transaction of any size, that you need to make sure that analysis is on your checklist.
Okay, got it. All right. Well, thanks very much, Larry. This is Roger Royce at the 10,000 Startups Podcast. We've been talking with Larry Shosid from Haynes and Boone about Hart-Scott-Rodino. Thanks for being here, and we'll see you all next time.
Thanks, Roger.